This is Committable. I'm Jesse Mangan, and for this episode, we're talking about protection and advocacy organizations. And I'm very privileged to have with me here today advocates and attorneys from Disability Rights Center, New Hampshire. For introductions, how about Lynn? Do you want to introduce yourself and say a little bit about who you are and the type of work you do?
Sure. I'm Lynn Clay. I'm the managing attorney here at the Disability Rights Center of New Hampshire, and I also manage our intake work. So we provide legal advice, advocacy, and information and referral to people with disabilities here in New Hampshire.
Fantastic. Next, how about Lauren? You want to introduce yourself?
My name is Lauren. I'm a certified peer specialist and a member of the PMA Council for the DRC here in New Hampshire.
Awesome. And Stephanie.
Hi, everyone. I'm Stephanie Patrick. I'm the Executive Director of Disability Rights Center, New Hampshire. I got into this field many years ago because I have a dad with a pretty significant mental illness. And so I grew up with that. And that was always part of my advocacy. And I'm excited to be here in New Hampshire. I've been here as the Executive Director for about 8 years.
So the first question, because I think the general public might not really understand what a P&A is. The first question is, what is a protection and advocacy organization?
I'll get started maybe with that one. So the protection and advocacy system was started back in the 1970s in response to abuse and neglect of people with disabilities in institutions like a place called Willowbrook in Staten Island. And our role is to provide legal advocacy to people with disabilities and to do that in a way that's independent from the state. So we don't receive state funding to do this work, and we can advocate many times against the state or against state programs that are really not respecting the rights of people with mental illness and other disabilities.
So with that funding, are you receiving just one lump sum, or is it coming from all these various sources? Like I think you have various grants. Can you talk a little bit about the type of grants you receive to do work in New Hampshire and what those different grants are asking you to do?
Yeah, so every state is a little bit different. Some states are funded in a little bit different way, but here in New Hampshire, we have 8 federal grants that make up the majority of our funding. We also get some small funding from our other councils and foundations and things like that, but our core 8 federal grants are to do different kinds of work. 4 of them are on behalf of people with certain types of disabilities, and we have a lot of flexibility within those to decide the work that we do. The other 4 are for specific types of work. And so I'll go through them. It's a lot of initials, but I will go through them if you would like really briefly each one.
Yes, please.
So one is on behalf of people with mental illness, and that is to serve people with mental illness, and all of our disability specific grants are to serve people in the ways that seem to be the most highest priority area here in the state of New Hampshire. So we spend a lot of time getting input from the community and looking at what's happening in the world to try to figure out what are the most critical issues where people need legal assistance, civil issues, and they're not getting help related to that, specifically on disability related issues. We have another grant that serves people with developmental and intellectual disabilities, one that serves people with traumatic brain injuries. And the last one of our specific disability grants is for people with other types of disabilities. It's kind of the catch-all for people who are aging with adult disabilities, people who are deaf, who are blind, people who have learning disabilities, all the other disabilities that don't fit within those 3 that I listed already. Then we have 4 kinds of funding that are specific to our work. So we have a program that specifically works on voting rights of people with disabilities to help make sure people with disabilities, regardless of their political affiliations, can vote privately and independently. We have one that will help people who are on Social Security benefits who want to work and are facing trouble with employment discrimination or trouble accessing vocational rehabilitation services or other programs to help people with disabilities who are on Social Security to get and maintain jobs. We have one related specifically to assistive technology. So that helps with ramps, communication devices, any kind of assistive technology that would help a person with a disability be more independent. And there's a wide range of that. A lot of our cases in that area involve trouble accessing assistive technology in schools or through Medicaid. Those are the 2 kind of main places where we do this advocacy that we're open to other types of work. The last one is called the Representative Payee Program. And it's a very different program designed to make sure that people who are acting as representative payees, which means they're overseeing the Social Security benefits of a person with a disability, are acting appropriately. They're managing the funds appropriately. They're giving accountings to the people with disabilities. They're listening to the people with disabilities about how they want their funds spent. And it's a monitoring and oversight specifically with Social Security to make sure that's happening as it's supposed to.
So you're receiving these different grants that kind of give you different purviews, different focuses, and one of those grants is the Protection and Advocacy for Individuals with Mental Illness, or PAMI. What is the PAMI grant? And with the PAMI grant comes an advisory council. So what is the PAMI grant? What is the sort of the focus it gives you? And what is the advisory council? And how does that assist your work?
So the PAMI grant is to serve people with individuals with mental illness. When it was established back in the 1980s, it was specifically to serve people who were in institutions, and that was the only way that the funds could be used. It was to serve people who were in psychiatric hospitals, nursing homes, and other facilities and institutions. A few years later, it was expanded to allow us to serve people in the community. But the institutional work is still a primary focus of that grant. It's still very important, as it is with all of our grants, because people who are in institutions are often much more isolated. They have less contact with the community. They have less ability to go out and advocate for themselves. They're very dependent on staff and the purviews of staff as to how you're going to be treated. I mean, you're in a very vulnerable situation when you're in an institution. And so that is really core to that work. We also, though, serve people in the community, and it can be on a variety of issues. I mean, we have cases related to institutional rights, related to education, related to employment occasionally, access to community-based services, so eligibility for services, mostly Medicaid-funded services. But really, there's a wide kind of purview of things that we can do with that grant. Lauren, do you want to talk about the PAMI Council?
Yeah, so the PAMI Council, we are a group of mental health advocates. We have a wide variety of individuals who serve on the council. So someone, who is a parent of a child with some mental health challenges. I myself serve as the peer specialist. We have individuals that serve as those with lived experience, those who have who may be clinicians who have experience working within the system. And so the group of us make up the PAMI Council. And so we kind of use our own experience and the experience of people in the community to guide and inform the Disability Rights Center of, the work that we're doing for those with mental health challenges. And so we've done several different projects and things over the years, from submitting letters to the editor, taking a stance on legislation. Previously, we've held panels, one specifically interviewing law students and an attorney about mental health support for law students and lawyers experiencing mental health challenges. We've promoted an art gallery that was the art of those with lived experience with mental health challenges and what placing what that experience has been for them in art form. And so we've done a lot of things to bring awareness to the public, so to inform the DRC, the Disability Rights Center, of mental health challenges, those with mental health challenges, what may be faced, what's been going on, and then also to try and bring awareness in the public. And then currently we are collecting data to better understand the effectiveness or therefore a possibly intrusive nature of conditional discharges. That's our most recent work.
Can you talk a little bit about what a conditional discharge is? Because I don't think I've heard that exact phrasing in another state. So what is a conditional discharge?
So in New Hampshire, once a person has been committed to our state psychiatric facility, there are two ways to get out. One is the hospital gives you an absolute discharge and you leave with no strings attached, or the hospital says, we think you could receive services in the community and you may leave the hospital if you agree to certain conditions, and that's where the name conditional discharge comes from. The conditions typically are you must attend all your appointments at the community mental health center, you must take your medications, and you must abide by whatever other conditions. But it's typically complying with all the treatment that the mental health center wants you to comply with, whether that's therapy, whether that's groups, take your medication, and attend appointments. The concerns that we have with conditional discharge are the conditional discharge lasts for as long as your commitment order. And in New Hampshire, commitment orders can be as long as 5 years, up to 5 years. And that's not uncommon to see commitment orders of 3 to 5 years. And so for the next 5 years, that person has to comply with all of these conditions, or their conditional discharge can be revoked and they can be returned to the state psychiatric facility. So it can be a very burdensome experience for people. And we hear from people all the time where their discharge is revoked because they missed an appointment or weren't at home when the mental health center came by with their daily medication. So it can be a very burdensome situation.
I have so many questions. So first question, this sounds very similar to an outpatient commitment order. Is there a court order in place with a conditional discharge?
So court order is for the commitment. And then once you're under the commitment, the law allows the state psychiatric facility and the community mental health center to require you to enter into this agreement, this legally binding agreement that says, yes, in order to be discharged, I will comply with these conditions. And under the conditional discharge statute, your conditional discharge can be revoked either because A, you have violated one of the conditions, or you are in such a condition as to be a danger to yourself or others. But it's an either or. So you miss an appointment, we can revoke your conditional discharge. You don't have to have both of those things. So it's not like you violated a condition and you are potentially at risk of being a danger to yourself or other people. The violation of the condition alone is sufficient to land you back in the hospital, potentially for the term of the commitment. So let's say it's year one and you've missed several appointments, you could potentially end up back in the hospital for the next 4.5 years or whatever the term that's remaining.
So if someone is ordered to a civil commitment and the length of that civil commitment is estimated to be, I assume it's up to 5 years. At any point, the clinicians can probably find a way to release you if they think you no longer meet the criteria. So up to 5 years of a civil commitment, is there a periodic review built into that law?
So the way it works is it's specifically tied to our state facility, mental health facility. And so in order to leave the facility, you don't have the option to stay at the facility. And in order to leave the facility, you need to sign this conditional discharge. So there is no other option. You don't have an option but to sign the conditional discharge because you're also not allowed to stay at the hospital anymore. And so once released, in my experience, New Hampshire does have 10 community mental health centers. My experience is with one, so do want to just disclose that, as I'm not sure how other centers may operate. But as to Stephanie's point, the state of New Hampshire was sued a little over 10 years ago, and part of that lawsuit was implementing a modality called ACT, which stands for Assertive Community Treatment. And that is a modality used to support those labeled as severely mentally ill. And for the most part, to my understanding, that when I was on that team, I did serve on that team for some time. Um, when a client is discharged from the state hospital, the community mental health center in which the client lives is the mental health center that takes on that quote unquote case. And in my experience, it's always that they are then discharged to the assertive community treatment team, or known as ACT. And so, when in my experience, we would, my supervisor would say, hey, like, would bring it to a team meeting and say, hey, this person is being discharged from New Hampshire Hospital. They would give us the details of who this person is, and when we would start meeting with them. So, and from talking to previous colleagues of mine, I'm almost certain that those clients are almost always, not 100%, but often placed on assertive community treatment teams. With that, the ACT team is required to review client cases. It is supposed to be every year. In my experience, it did not happen that frequently, but that is what is written in state law.
So the way a lot of these laws work is do what we say or else. And so in this situation, they're saying we're going to release you. And if you don't meet our expectations, we're going to bring you back. That's the or else.
Mhm.
What does that look like? Does that mean police are being sent to someone's home to bring them into a facility because a clinician thinks they missed an appointment?
Yes.
Under the law, they're supposed to, if it's safe, give the person written notice that they have received, that they have violated a condition, and ask them to come in for an examination. But yes, it is often the case that the police are sent to bring someone in, which can be very traumatizing. Lauren, did you want to comment on that some more?
Yeah, so I've definitely experienced police going out. That tends to be the typical procedure in New Hampshire. The 988 initiative was supposed to reduce the number of police officers attending to that. I am not sure how successful that's been, but when I was witnessing this happening, there were times where case managers would go to serve clients the paperwork in the same moment that they are also taking them to the hospital. So it was like a two-in-one thing. They would give them this paperwork while also being there to transport them to the nearest ER. And then from there, they are transported to the state hospital.
So I've talked to people in other states, people who are actually advocates for outpatient commitments. And one of the things that they've said to me about outpatient commitments is that they would prefer that they be offered to the person who's coming out of an inpatient commitment, that right before that inpatient commitment ends, you give them the offer. We can release you a little bit early if you agree to this outpatient court order. The thing that I've always understood about that in other states, though, is that the person can say no. The person can say, I would rather stay inpatient for a week and leave completely free than transition to 6 months or a year or 2 years of an outpatient commitment order. So, what I'm trying to reconcile with what you're saying about conditional discharge is it seems like I'm trying to say this as respectfully as possible. It seems like a workaround because federal precedent establishes the commitment has to be the least restrictive option possible. If an inpatient commitment no longer becomes the least restrictive option, that should be it. That should be you're a citizen, you're free to be about your life now. And so, just from my impression of what you're saying, please correct me if I'm misreading this. It sounds like a workaround to get someone out of a facility so they're no longer paying the really high amounts of money that it requires to keep people inpatient. They're no longer paying for that, but that person is not free. They are not given the full spectrum of their rights after that point. I guess, am I missing something? Is there something I'm misinterpreting?
I mean, from my experience, majority of, or really all of the people that I worked with who were on conditional discharges were not really wanting to be on a conditional discharge. And so, like I said, like, from what I know and what I witnessed, it is meant to be a choice, but it's a involuntary choice. If you're being told you're being discharged from the hospital, you can't stay at the hospital, but you're not allowed to leave unless you sign the conditional discharge, then that's not really, there's no real option there. I mean, you're not allowed to stay at the hospital, but you're not allowed to leave without having some condition to you leaving the hospital. I mean, it's so clients end up on an assertive community treatment team already resistant to what is being forced on them.
What happens if you don't agree to the conditional discharge? Does any, like, what are that? I don't know. What would happen?
I've not worked at New Hampshire Hospital, which is our state facility. I'm not really sure what their condition is. So I'm not sure on that side. I've always been on the other side of receiving individuals from the state hospital. I don't think they really have a choice, but I couldn't really completely speak on behalf of what happens at the hospital because I do know that it is signed. There are 3-year conditional discharges, there's 5-year conditional discharges. I've seen discharges not be renewed. It's rare. Almost always it is renewed, and people are on these. They're not just for 3 or 5 years, they're on them for 10, 15 so years because they are automatically renewed based on the client's worst point in which their mental health symptoms showed. So if 10 years ago this is what you presented and that is your worst presentation according to clinicians, they use that as evidence to renew the conditional discharge.
Yeah, one of the things in New Hampshire is that a person could have a 5-year commitment. They're in the hospital for maybe 6 months. They're released to the community and they're on this conditional discharge. And they see the end in sight eventually, right? They're coming to the end of that 5-year term. The community mental health center can petition the court to put the person back on a conditional discharge for an additional term. So our law allows that. There is a legal process that the community mental health center has to go through, but it is possible, and there are individuals who can be on a conditional discharge for many, many years as a result of that.
So all of my hospitalizations, involuntary, voluntary, civil commitment, they were all in Massachusetts, so different state. But in my first hospitalization, which was for anorexia, so there's a weight component, there's a added component to that. They usually have a number. You meet this number, we discharge you. When I was released, it wasn't a conditional discharge, but I was at a university and it was University Health Services that sent me to the hospital and they said, we're going to let you go. We're going to let you leave the hospital, but you cannot attend classes. And if you do anything other than go home, go to your parents' house, you can't leave your parents' yard. They actually told me that. You can't leave your parents' yard except to go to a nutritionist appointment, a psychiatrist appointment, a psychologist appointment, a physician appointment. Every week, you got to go to those. And if you don't, you won't be allowed back in school. And if you don't, maybe we hospitalize you again. That only lasted a couple months before they told me, well, now you've missed school, so we're going to medically discharge you from school. That was about 2 months and was quite possibly the most frightening and miserable 2 months of my life because I wasn't in a facility, but I was constantly afraid. I was constantly afraid that all of the people in my life who were told that I needed to be monitored and I needed to be watched, they'd created a surveillance state around me. And that was just constant fear, constant just spiraling. It got so much worse under that pressure and that stress. So, as you're describing a conditional discharge lasting for a year or 5 years or 10 years, I'm wondering if anyone involved in this process has ever spoken to someone who's had to live with that fear that everyone around me has been told to watch me, that I'm being surveilled, that am I really free? Am I really allowed to live my life, to make my decisions? How do I make plans for a job? How do I make plans for school? If I have to think, maybe the police come to my job and take me back because I missed something. Has anyone involved in this process been told what it's like to live under that fear?
So when I was working on the ACT team, that's exactly what I was experiencing almost on a multiple daily basis. I mean, pretty much every client I worked with was absolutely infuriated that this is the situation they were in because of an episode of psychosis due to substance use, an episode of psychosis because of trauma, because of a certain incident. And, I there was not one client I worked with that didn't have some type of trauma to begin with. And so putting something like this in addition to trauma that's already existed just escalates that situation. I had all of them, all of them. I really don't know. I maybe one, to be quite frank. I had no one client who thought his conditional discharge was really supportive for him. And that was out of the hundreds of clients I met over an 8-year period. And so they are all, and that kind of to the point what I was saying before, which is that, clients are discharged, they're placed on the ACT team, and now they're coerced to meet with, it's really, you have to have at least 3 to 5 appointments a week. You need to meet with a psychiatrist, you can meet with supportive employment, a nurse, peer specialist, and then you have your case manager and a therapist. And you're meeting with all those people either weekly, monthly, but the psychiatrist doesn't always weekly, and same with supportive employment. But you have to have 3 to 5 appointments a week. You're required to take whatever medication you are told to take. And so it is really hard. It's I rarely saw clients listen to when they're, telling people that they have symptoms or side effects of medications, that it is making it hard for them to work. I've had clients who missed appointments because they forgot or they were out to dinner with family, and their conditional discharge has been revoked for those reasons. And yeah, it's really hard. It was my job. I heard it all the time. And like I said, then what happens is these conditional discharges extend, and the process is there is a process with community mental health centers, but it's not really complicated. I've seen clients petition like that they disagree with the decision. I've never seen one win. In all the time I worked on the ACT team, I can think of one client that was actually discharged from his conditional discharge. They're just constantly renewed. So it's a lot of fear. And as a peer, it was very hard because there's only so much I can do as a peer specialist. And, I have clients who have severe substance use who, are prescribed Xanax, and they're telling the psychiatrist, like, why are you prescribing me Xanax? And now they're required to take that medication, even though they have a substance use condition. Like the fear and the frustration amongst people placed on these conditional discharges is incredibly high and really hard to listen to on a daily basis. And, there's not a lot of room for clients' voices. And so you have a set of people who are, not everyone on the ACT team has a conditional discharge, but many do. And they're not necessarily listened to. Their voice doesn't withstand the opinions of clinicians. And I've heard people say and doctors say, if the client isn't well enough to keep all of their appointments, they're not well enough to be in the community, and they have revoked their conditional discharge for that before missing an appointment. And it makes it really hard to hold a job or to have a life, you know, having that many appointments in a week. And the voices of clients aren't heard. They're not listened to. They're not taken seriously. They're not they're not taken into consideration. They're like, well, I was meeting with my family. Then, they're like, well, you knew you had this appointment. You should have arranged that appointment with your family around this. And now it's the client's fault. But there's no accountability if the provider needs to change the appointment. So that client needs to remember 3 to 5 appointments a week, who is coming when, how long they're going to be meeting for, et cetera. And then if one provider or more than one provider ends up changing that appointment, now you have to make sure that anything you arranged around whatever you had scheduled is now rearranged because that provider is now changing the time they're meeting with you. And that's all on the client to manage. But there's no accountability. Like if they miss it, but they thought the appointment was on Thursday at 1, but the provider changed it to Friday at 2, and now they forgot that, then that's on the client to remember. And now that's held against them because of this conditional discharge, for example.
I think if you take the perspective of the person going through the process, there are a lot of concerns that will almost immediately be raised with the question of conditional discharges. And with a protection and advocacy organization, you have a federally funded organization that has the capacity to investigate, to monitor, to look into something and ask questions. And with the PAMI grants, specifically in the PAMI Advisory Council, you have people with various experiences, including people with lived experience, who you can collaborate with and work with to ask more questions. So with that collaboration, what sort of questions are being asked? What sort of work is the P&A and the Advisory Council doing to try to collect data or ask more questions about conditional discharges?
So we created a survey. So we've been talking about conditional discharges for some time. I brought it to the council's attention because it's not something well known. It's something I witnessed on a regular basis for 8 years. And I saw this and thought, how can no one know that this exists? And so I brought it, I joined the PAMI Council, and that's been my focus ever since. And so recently the PAMI Council decided like this may be something we should really look into. And we had all agreed that to gain some insight as to what people with lived experiences with conditional discharges, how they feel about the conditional discharge. The kind of question that we raised was, with this conditional discharge, because I know that families of people who have conditional discharges, they can at times have a different opinion than the clients. And so there can be a lot of support for these conditional discharges or medications, et cetera. And so our thought was, okay, well, how are these conditional discharges improving the quality of life for those on the conditional discharge? And how can we know that without gaining some insight from people who have had or are on conditional discharges? So therefore, we created this conditional discharge survey asking people to complete the survey anonymously so we could gain some understanding as to what does it mean for those on the conditional discharge, not the families, not the loved ones, but what is it like for them? How has it improved their quality of life, or how has it decreased their quality of life? So that's what we are in the process of doing right now. We have not completed our data collection. We are in the process of collecting data.
A couple of years ago, I was in New York and had to rent a car, and the person who was it was a situation where the person at the rental car agency had to drive me somewhere. And the person who was driving the car used to work for an outpatient commitment team in New York. And so he's telling me about, well, sometimes people will leave the county. They'll be on an outpatient commitment. They'll leave the county. We go talk to the other county, tell them to pick up that person and bring them back to our county. I was like, well, I questioned the legality of that, but okay, keep talking. And then he was like, well, so I work with housing. And sometimes if someone's brought back into a facility, we'll talk to the landlord, and the landlord's like, I don't like this person. So we'll tell the landlord how long the commitment is. And the landlord will be like, well, I'll start initiating eviction then, because if they're gone this long, I can start to evict them. And the thing that always strikes me about these conversations, because my disability is not evident. I can walk through society, and as a white man, if I just smile and nod, people will think I'm one of them. And so, one of the things that continually strikes me in all these conversations is that people view the other people being put through this process as them. They don't stop and think, if someone created this law and I thought it was targeting me, what would I want to know? What would I want to hear about? And so I just always want to implore and encourage legislators and attorneys, anyone involved in this process, just for a moment, imagine, what if that was you? Because it can be. All of us can be disabled in some way at any moment. It can happen to anyone. I think it really highlights the importance of having someone who thinks, why don't we ask people what they're experiencing? And is this right for them? Yeah. So thank you for doing that. Um, as we wrap up the interview, is there anything else about protection and advocacy organizations or the Disability Rights Center in New Hampshire that you think people should know? Anything, any of the work you're doing that you want to highlight?
I mean, I would say the most important thing is, our work is only as good as knowing what the issues are. I mean, I think it is important that we hear what is happening. And I think Lynn and Lauren are both really key to that in terms of Lynn, who's the one talking to the people who call us for help. Lauren is out in the community talking to people also who have experiences, and that is how our work is best informed. I mean, I think we have to be realistic about the resources that we have available because we don't have enough resources to do all the things that would be on our list. And so we're constantly making difficult choices about what's the highest priority, who we can help, the individual cases we take, and the systemic cases that we do. But we really need to know what is happening and to know about these issues and then use all of the tools at our disposal. So our advocacy, our outreach and training, our public policy and legislative work, our individual representation, our systemic litigation, all to kind of bring all of them to the table to try to make things change and make things better for people with mental illness and people with all kinds of disabilities in New Hampshire.
So there was recent reporting that suggested a proposed budget from the Health and Human Services, which suggested that people were considering cutting funding to the Protection Advocacy Organization. What would you say to someone who was asking, why should we continue to fund this?
I would say, we help the people whose the system is supposed to help when it's not working. We are the ones who can be that fail safe when the system is not working like it's supposed to. And that's not meant to say that it never works like it's supposed to, because it does work for a lot of people in ways that are effective, or most of the time works for these people in ways that are effective. But we're the people who can hold systems accountable when they're not working as they're intended, or even look at systems that are working as they're intended, but are not protecting the rights of the people with disabilities who are involved in them and make them better. And that's a really important fail safe that you need in every state to be able to be sure people with disabilities are living the lives that they want to live in the communities with their friends and family, just like every one of us wants.
So thank you all for the work you're doing, and thank you for being here.
Thank you.
Thank you for having us.